Greetings, everyone. Welcome to the DC Bar Pro Bono Center's webinar, Nonprofit Dissolution: How to Decide if Winding Down is Right for You. Brought to you in partnership with Covington Burling and the Office of the Attorney General for the District of Columbia. I'm Daryl Maxwell, an Assistant Director of the DC Bar Pro Bono Center. Before we get started, I'd like to say thank you to a few people first. First, I'd like to say thank you to my colleague, Lauren Paley, for helping make all of this happen, helping with the webinar's implementation and with client outreach. Next, a huge thank you to our friends at Covington and at the OAG. David Martin, Lauren Rakitin, Brian Yang, Susie Tumanian are all members of Covington's transactional practice and will be helping lead our discussion today. In addition, we have the added benefit of Catherine Jackson, who manages the nonprofit and charitable enforcement at the OAG. She is the chief of the public integrity section in the public advocacy division. David will introduce the discussion of dissolution. Susie will discuss pre-dissolution considerations, dissolution steps under DC law, resolution to dissolve. Next, Brian will touch on many of the facets of winding down an organization. Catherine will handle notice to the OAG and some FAQs. Lauren will then address potential claims that may arise while winding down an organization. One last thing before we get started. I'd like to go over some logistics for the webinar. Just so you know, this webinar is being recorded, so if you want to pass this along to your friends, we will make this available on our resource site, Law Help. If you're looking for the PowerPoints or handouts, there is a tab in your GoToWebinar panel called Handouts that has a copy of the presentation as well as some frequently asked questions, which we will be diving into as well. As if you have questions, and I'm sure you will during this webinar, there is a question box on the dashboard of GoToWebinar. Type in your questions there. I will share them at a couple different points with our presenters. In these extremely dangerous and unsure times, for nonprofit organizations have to consider whether their funding sources are stable, have to determine whether layoffs or furloughs may be necessary. They may even need to make decisions about whether or not to close their doors. Our team, led off today by David Martin, will lead this discussion to give you some much needed advice on the most sensible steps to move forward. David, I turn it over to you.
Great, Daryl. Thank you very much, and good day, everyone. We are really pleased to be with you today. Before jumping into the program, I did want to say a few words by way of introduction. First, back at you, Daryl. Leading the list of thank yous is mine, thanks to the DC Bar Pro Bono Center. I think most of you know what a great service the Pro Bono Center offers to the DC area, but including to nonprofits and small business. So I would like to simply say, on the behalf of Covington, our sincere thanks to the center for all that it does, and especially today to Daryl Maxwell and Lauren Paley and their colleagues in the nonprofit and small business wing of the center for making the webinar possible. Second, I'd like to also give a shout out and thanks to my colleagues, Lauren Rakitin, Brian Yang, Susie Tumanian. I'm not sure that they knew what they were signing up for about a month ago when they raised their hands to help with this project, but I can tell you that since then, they have missed no beats and working seamlessly together, and in a very short order have pulled together a clear and complete program that I hope you will enjoy and find helpful. And finally, my thanks goes out to Catherine Jackson of the Office of the DC Attorney General. Catherine got the call for the program with little warning, but she enthusiastically joined the team and has added significant input to our thinking and our materials. As you will hear and probably already know, the Office of the Attorney General plays a big part of the dissolution process, and having Catherine's insights and perspectives really rounds out the program in a very special way. Next, I'd just like to say a very high level, set the stage, if you will. statement of why we're doing this program and what we hope you take away from it. Dissolution is, as most of you know, an important stage in the corporate evolution, no less so than corporate formation, for instance, but in many respects, it's notably more complex and nuanced than formation, and that alone should be a reason for us to cover it. Also, it turns out that dissolution does not get much attention when it comes to legal commentary or professional learning and guidance, and we hope this program is a small attempt to fill some of the void in that area. And finally, as Daryl has mentioned, we are in an economic environment in which the dissolution process is likely to be tested more than is typical. And so also for that reason, we think it's timely to give this program. What we hope you take away from it, we hope that you will get an understanding of the decision-making, the statutory framework, and the legal landscape that surrounds the dissolution process. As Daryl mentioned, we're going to do this in 4 parts that follow the chronology of the dissolution steps, each with a different presenter and a different voice. Hope you enjoy the program, and I'm going to turn it over to Susie if you'd like to start us on our journey.
Thanks, David. That's a great segue into the first section of our presentation, starting on slide 2 with pre-dissolution considerations. The first phase of your organization's possible dissolution process, before looking into all the steps required by law and signing the relevant documents, is to have a frank and open discussion with your team about the challenges that the organization is facing. Every organization is different and has its own issues, but at their core, many will boil down to the 4 points we've listed on the slide. 1, the inability of the organization to pay employees or meet other liabilities or obligations. 2, a lack of funding and adequate donations, especially in light of the current economic situation. 3, an inability to make budgets, like if spending outpaces funding for too long. Or 4, mission failure or completion. Sometimes the purpose of the organization is no longer feasible, or on a more positive side, has been fulfilled. The decision to dissolve the organization should be holistic, taking all facts, circumstances, and projections into account, and involve key stakeholders like the directors, advisory board members, management, significant sources of funding, and outside advisors like consultants, lawyers, and accountants. Part of this discussion should also include the following 3 considerations. 1, evaluating alternative scenarios, such as a strategy shift, new source of funding, or delay of dissolution. 2, contractual and other obligations that could be triggered by dissolution. Having your organization's legally binding documents organized in one place would be helpful here. And 3, assess actual and potential assets and liabilities. Knowing what the organization owns and owes will not only help inform your decision at this stage, but also prepare the organization for the wind down phase. Now, the remainder of this presentation assumes that your organization has gone through this discussion process and determined that it is an appropriate time to dissolve the organization. Turning now to slide 3. Maybe. Yep. Okay, slide 3, I'm going to give you a brief overview of the formal dissolution steps under DC law. Dissolution of nonprofit organizations is governed by Section 29-412 of the DC Nonprofit Corporation Act of 2010 and is easily found online. The dissolution process is administered by the Department of Consumer and Regulatory Affairs, known as the DCRA. Now, the 4 main steps in the dissolution process are: 1, adopting a board resolution to dissolve the organization. 2, winding down by settling the liabilities and distributing the assets over the organization. Note that this process can start before you pass the board resolution, like when you prepared a list of the organization's assets and liabilities during the discussion phase, and can continue after you file the articles of dissolution with the district. Brian will talk more about that process in a couple minutes. 3, sending a notice to the Office of the Attorney General, known as the OAG. We are lucky to have Catherine from the OAG's office, who will talk more about that process later on in the presentation. And 4, filing the articles of dissolution with the district. I'm going to go into it. Yep.
Susie, this is David. Do you mind if I interrupt at the end of this slide here?
Of course, go ahead.
Yeah, I was just going to put in a plug for the DC law generally. I think many of you might know that the DC law follows the Model Nonprofit Business Corporation Act section, so it's like many other state laws. But I will have to say that many states don't even have a nonprofit statute, and I think we're very lucky in the District 1 to have a fully formed nonprofit statute that's separate from the for-profit code, but also one that has been kept up to date by the district. And I think the current version is in play for an updating, in the next year or two. So I think we have a good statute to work with in the district, which is also good because we have lots and lots of nonprofits in the district. Back to you, Susie.
Great, thanks, David. That was helpful. I'm going to go into a bit more detail about step number 1 that I just mentioned, which is the board resolution on the next slide, slide 4. As I said before, passing a board resolution, which essentially says that the board discussed the possibility of dissolving the organization and believes it's in the best interest of the organization to start the dissolution process at this time. This resolution must be approved by a majority vote of the directors, or more if required by your organization's articles of incorporation or bylaws, either at an official board meeting that satisfies all of the formal requirements for having a board meeting, like proper notice and quorum, or by unanimous written consent, where all the directors sign the written resolutions. For a member organization, and these are not very common, you must also obtain approval by majority vote of the members, or more if required by the articles of incorporation or bylaws, either at an official member meeting or by unanimous written consent. So that was an overview of step number 1 on the board resolution, and I'm now going to turn it over to Brian to talk about step number 2, the winding down process.
Thanks, Susie, much appreciated. So I'm switching now to the next slide. Sorry, one sec. Oh, there it goes. So switching down to the next slide about winding down. The winding down process is where a corporation takes inventory of what it owns, what it needs to pay, and then to go about settling the various obligations of the corporation. One thing to note about winding down, as was mentioned by Susie, is that winding down can take place before board resolutions are passed, as well as after the articles of dissolution are passed. It's not something that needs to start at any particular time, and it's usually, I think, helpful to actually start earlier rather than later this process. I think one thing to make clear is that passing board resolutions, passing articles of dissolution, this does not in of itself accomplish the wind down process. So oftentimes one question that's commonly put forth is whether or not it's necessary to go through this process. And so this process of winding down is something that the corporation is going to need to take some time to take stock of its inventory, to devise a plan of distributing its assets. It's going to require reaching out to various appropriate counterparties. So this could be banks, this could be service providers, this could be landlords. And it's going to require, in some cases, settling existing liabilities. In other cases, it will require terminating existing arrangements. One thing that's important to note here is that in the process of distributing various company assets and thinking through this process is that the various corporation articles, bylaws, the various fiduciary duties of directors and officers, all of these things still apply in this process. So when thinking through how to distribute assets and in what way to distribute assets, it's important to take into account the various obligations that directors and officers may have under the particular articles and bylaws, as well as under the more general sort of DC code fiduciary duties. One example of this is in cases where the corporation is a 501c3 organization, basically that they have exempt status for tax reasons, is that when distributing assets, for example, the assets are going to need to be distributed for an exempt purpose. And this is something particular for 501c3, but it's important to take stock of the particular nuances of one's articles and bylaws. Moving on to the next slide, I'll get into a little bit more of the specifics about steps that are typically taken in winding down. So this next slide covers specific types of actions that are typical in wind down. One of them that's very common is you'll want to take a stock of the various contracts that the corporation has entered into. This could be your lease. This could be contracts with different vendors. This could be your insurance policies. This could also include any sort of grants that have been received from donors. It'll be important to look carefully at the various contracts to see what termination provisions are available before you go about approaching different counterparties. One particular note on insurance, it's often the case that insurance policies may actually cover a much longer period, and so sometimes it's actually possible to obtain a premium refund for part of the insurance policy. But one thing that you'll need to make sure to do is to ensure that the insurance still covers the wind down period itself and doesn't simply end upon the articles of dissolution. One thing to note specifically on existing grants, in addition to looking at terms and conditions, sort of like what you would do with contracts, it's probably a good idea to consider what is going to be done with existing funds from those grants. Sometimes that might be, you might use the funds to pay off liabilities. In other cases, you may need to return the funds to the specific donors. And in other cases, it might be a matter of distributing them to a different nonprofit organization, but just something to look at carefully. And finally, one thing to note that needs to be done is the IRS Form 990. So the IRS Form 990 is sort of the equivalent of a tax return for a nonprofit organization. And this is something that needs to be completed during the year in which the dissolution takes place. And one of the things to in particular point out about this Form 990 is it includes what's referred to as Schedule N. And Schedule N is actually a listing of the various assets that are going to be disposed and how exactly they're going to be disposed. So a lot of the work that you may have done already up front at this point in terms of figuring out what's going to happen with assets, how they're going to be disposed, this would all sort of find its way into the Schedule N as well. And then moving on to the next slide here, we had a set of just frequently asked questions that we often get about winding down, and this is also a time where we're also happy to take questions if people have them. I'll sort of start going through these frequently asked questions, and then we'll give a little bit of time at the end. One question that we often get is, what happens if a corporation doesn't have the funds or the assets to be able to pay off all of its liabilities? There's no hard and fast sort of answer or clear rule for this, but according to the DC code, directors and officers, they do have an obligation to cause the corporation to discharge or make reasonable provision for the payment of any claims. In other words, the directors have an obligation to make reasonable use of the funds that are available and to try to pay off the debts to the extent possible. In the event that the corporation doesn't have sufficient funds for particular debts or all debts, and it's going to be a matter often of reaching out to various creditors, various vendor people the corporation works with, and sort of arranging with each of those different parties how exactly the liabilities are going to be addressed. Another question that's often sort of put forth is whether one is actually legally required to engage in any of these wind down activities. And the sort of short answer is no, in terms of there's no legal requirement to engage in any of the specific wind down activities. But that being said, there's usually a general obligation on directors and officers to engage in appropriate wind down activities and to sort of use appropriate fiduciaries. And so I think the expectation usually would be that directors and officers of a nonprofit would go about sort of going through this wind down process. Another question we often get is whether directors and officers need to use personal assets or perhaps take out a personal loan to pay off debts of the corporation. The answer to this is that no, that debts that are in the name of the corporation do not need to be by the directors or officers. The corporation, because it's a separate legal entity, it protects individual directors and officers, subject to them fulfilling their fiduciary duties from personal liability. A fourth question that's often posed is whether contributions to the nonprofit corporation continue during the wind down process. Now, there's no explicit prohibition against soliciting contributions during the wind down process, but as a general matter, a dissolved corporation will typically cease accepting charitable contributions. It is possible in certain instances, and it would require being, I think, upfront and clear with donors about how the funds are going to be used, whether it's to pay down liabilities or to sort of address any sort of fees in the wind down process. That would be perhaps one of the few exceptions, but as a general matter, contributions typically aren't solicited during this time. And the last typical question that we get before questions is whether a nonprofit should announce to employees, to donors, to the public that it's in the wind down process when it's happening. Again, there's no hard and fast answer. It's going to depend very much on particular circumstances. But there are some benefits, we think, to making it public to others that the corporation is in the wind down process. This sometimes makes it easier to dispose of claims because people are aware of them. It helps to often ensure timely resolution of claims. It's just easier sometimes to announce it to everyone, so it's just communication is faster. And it also allows for employees of the nonprofit, for donors, for the public to be able to sort of make alternative plans as needed. But one sort of consideration is that there is sometimes the downside that different creditors may sort of aggressively seek sort of settlement of debts of the corporation. So it's something just to be aware of as well.
Hey, Brian, I did have a few questions. Okay, the first one is a final audit required as part of dissolution?
Hi, this is Lauren. I am happy to take that. The audit itself technically isn't required, but it would be required to file a final closeout 990, which is the final tax return, which will ask for your final audited numbers. So in that way, I guess it would be indirectly required, and the final 990 to the IRS would be due within 5 months after the effective date of dissolution.
Okay, great. And then the other question I had was, when, if ever, would a nonprofit want to consider formal bankruptcy proceedings?
This is David. I'll jump in on that because it's a conversation that we have oftentimes with our bankruptcy colleagues. And it's a complicated question. I'm not a bankruptcy lawyer, so just consider the source. But the way I translate what we've been talking about in-house is that if you're a large nonprofit with lots of creditors and a complicated balance sheet, sometimes seeking the protection of restructuring in court is a viable option for a nonprofit. It takes longer and it's more expensive, but it certainly gives you a orderly way to make sense of what you're trying to dissolve. With many nonprofits that are smaller, they understand their balance sheet. They know the creditors personally. They know sort of what terms and conditions exist in the real world with respect to their liabilities. And they end up, I think, having a better road to hoe if they basically prepackage their bankruptcy by going through dissolution. That is, work with your creditors, work with your assets, and do the best you can. There's a little bit of, you can't get blood out of a turnip situation here, and most creditors are not gonna be so stubborn as not to negotiate. So it's a real judgment call. If you're big and you have a complicated credit situation, going into court with a restructuring and a bankruptcy lawyer may be the right thing for you. It will take longer and it'll be more expensive, but it may get you to the finish line in a better way than if you did it on your own. But for many smaller nonprofits, I think bankruptcy suffers from the expense and the length and really getting you to no different place than you can get to on your own. But I'm not a bankruptcy lawyer, so consider that source.
Thanks for that, David. I think we're going to move to Catherine next.
Hey, Daryl, before Catherine takes over, I just had a couple of notes with Brian's section I thought that I just mentioned. Brian talked well about checking your contracts and understanding all that, and then also the participation by directors in collections and contributions, et cetera. There are two situations that we've seen before that I think sort of fit on this page. One is a credit card in the name of the organization that's guaranteed by a director, which sometimes happens. And that's a situation where it isn't a director paying a debt of the corporation, and we've already said that doesn't have to happen, but it's a director that may have to pay his or her own debt because they guaranteed the credit card. We also have seen situations where there are outstanding loans from directors, or for that matter, donors, but where directors find that they want to forgive the loan as part of the restructuring. So Brian's points about knowing where all your documents are and what the legalities are, and also understanding the role that directors are playing sometimes means that they actually will be ponying up some money towards the dissolution. And I'm done. Catherine, it's over to you.
Great. Thank you, David and Daryl. This is Catherine Jackson from the Office of the Attorney General. And before I start moving through the slides, which I'm going to start trying to do right now, I just wanted to say thank you to Daryl and the DC Bar Pro Bono Center for setting this program up. And thanks to all of the team at Covington for working on this, coming up with a great program. And I'm very happy to be involved and to provide more information to the nonprofit community about OAG's requirements in terms of nonprofit corporate dissolution, as well as just talk about the formal regulatory steps. So I will attempt, oh, there we go. Okay. So I'm going to talk about, again, the formal steps that are required under the Act in order for a charitable corporation to dissolve. And that's basically notice to the Office of the Attorney General and then filing the articles of dissolution with DCRA. And I'll just echo what Susie and Brian both said earlier, which is, you know, many nonprofits think of those steps as the first steps in the process. That's definitely not necessary, and I'll even say preferred. We certainly prefer that companies are well down the road of winding down and organizing all of the various factors that Susie and Brian just talked about, you know, before they actually initiate the dissolution process and before they provide a notice to our office. And some of that will become more obvious as I talk about what OAG looks for when it's reviewing a notice of dissolution. But I think it basically gets down to the point that while these are formal steps that are needed, a lot of the work of dissolution goes into the winding down process and resolving the affairs of the corporation. And that can occur before the notice is given or before the authorization of dissolution is filed. So with that being said, the notice to the Office of the Attorney General is required under Section 29-41202G that requires that the corporation must give notice to the Attorney General before the time it delivers articles of dissolution to the mayor. In this case, the mayor is now DCRA, the Department of Corporate and Regulatory Affairs. And notice to the Attorney General shall not delay or otherwise affect the dissolution process. We'll talk about this a little more when I get to the FAQs on this part of the presentation, but that is certainly a question we get a lot. And again, the Act makes clear that this notice to the Attorney General runs basically on a parallel track to the regulatory filing with DCRA and the dissolution from that respect. Going back to what OAG requires, our policy is to request the notice of dissolution at least 1 week prior to the date of dissolution found in the authorization, and the notice should include the following information: the corporation's name, the corporation's charitable purpose, which is obviously the purpose or purposes for which it has been incorporated and for which it has used to get any tax-exempt status, depending on the specifics of the organization. And one thing that we found is it's very helpful for us if, when you're providing this notice, you know, many corporations will just identify the purpose or maybe sometimes identify one or two of their purposes. We find it very helpful to actually have copies of the organization's current articles of incorporation and bylaws, because we're going to look for those anyhow. So it's very helpful for us to be able to provide those documents with your notice to OAG. So, you know, we can get a jump on that process, and there's not going to be any question about the entirety or the completeness of the identification of the charitable purpose. The next fact that needs to be in the notice is how and when the dissolution was authorized. And again, here we find it most helpful for you to actually provide a copy of the resolution or documentation of how the dissolution was authorized. Again, providing a date and that it was duly authorized by the board may be required by the notice, but we're going to reach back out to you and ask for whatever kind of formal writing or documentation you have of the specifics of that authorization. So if you can provide that up front, that's very helpful to us. The next fact is the reasons for the dissolution, and then the nature and dollar value of the corporation's remaining assets, and then the proposed disposition of any significant remaining assets, including the recipients of those assets. As Brian mentioned earlier, those recipients generally have to fit into the requirements of the dissolving organization's tax-exempt status, charitable status, and what we're going to look for, which I'll talk more about in a minute, is, does the distribution of those assets and the proposed recipients of them, is that consistent with the organization's charitable purpose, or is there some kind of concern or conflict there? And again, this gets back to the idea that it's very good to have as much of the wind down process together as possible, because if you're not able to provide that information in the notice to the Attorney General that the organization first sends to our office, we're going to reach back out and ask for more information on that, because that's really a key part of our review process. And I'm moving to the next slide, or trying to. That will talk more about our review process. There we go. So while the notice to the Attorney General and the requirements for the information in that notice are specifically laid out in the Act, there really isn't a prescription as to what factors the Attorney General must consider in reviewing the proposed notice of corporate dissolution that we get. So our review is basically guided by our overall role in terms of nonprofit corporations and charities, and why the Attorney General is involved at all. And that really ties back to the Attorney General's historical role at common law, and now that that's incorporated into statutes, in particular, as David pointed out earlier, our Comprehensive and Helpful Nonprofit Corporations Act. But the role of the Attorney General has traditionally been representing the public as a beneficiary of a nonprofit trust or a corporation. The idea obviously is, that the shareholders or interested parties of these kind of charitable corporations are essentially the public and the public interest, and the Attorney General therefore is responsible for looking out for that public interest. And that's the theory under which we review notices of dissolution from nonprofit corporations. And our overriding concern there is, again, ensuring that the purpose of the corporation is going to be continued through an appropriate disposition of the charitable assets, that there are no outstanding concerns that interfere with the ability of the dissolving nonprofit or the recipient of any assets to continue those purposes in a way that's appropriate and will actually benefit the public here in the district. So that is the overall theme of what we look at. There are a few other specific things that we look at when we get notices of dissolution. And again, this goes to my other overriding theme, which is please provide as much information as you can up front, because that's very helpful to us and will stop us from needing to go back to the organization at a time when they're, obviously very distracted by trying to dissolve and trying to wrap up a number of other matters. We really appreciate getting as much information as we can, so we're able to just commence our review and not be going back and forth asking for additional information. That being said, sometimes organizations will provide a more cursory notice, so we will need to look at it a little more carefully and probably reach out to the organization maybe a few times to get the information that we need. So when we get the notice and it's appropriate and has all the information that we need, as I just discussed, one of the first things we look at is this an organization that's subject to the requirements of the Act in terms of providing notice, and that those requirements apply to what are called charitable corporations under the Act. And the definition of that is found in the definition section of the Act, and it's very clear. But essentially, it's a domestic nonprofit corporation that is operated primarily or exclusively for one or more charitable purposes. And if you're at the point where you're dissolving your organization, you're going to be pretty clear on whether or not you're a charitable corporation, a domestic district corporation. But we do get people who will ask us questions or sometimes send notices when they don't necessarily fall into that category. And then we're happy to work with you on whatever questions you have about that. But if you are dissolving and you have any question as to whether or not you fit into the category that's required to follow the notice procedure, I would recommend that you reach out to our office, and we're happy to talk to you about that. The next thing that we look at is, was the information in the notice sufficient to identify how and when the dissolution was authorized? If we don't actually have a copy of an authorization or some other writing evidencing that the dissolution was performed in an appropriate way, we will reach out to the corporation and ask for additional information. Sometimes that may be board minutes, it may be some other kind of writing, but we will ask for a relatively specific level of detail on that point. And then again, what we look at is the dissolution consistent with the requirements of the Act and the corporation's own organizing documents? This is very important and gets back to a point that Brian made earlier, and that also goes into the disposition of charitable assets. If you're a corporation that's organized for a specific purpose, say providing educational services to a certain designated segment of a population, then if you provide a notice of dissolution that tells us, we are interested in distributing our assets to, another group that is involved in a certain type of advocacy that has nothing to do with education, we're probably going to reach out to you and talk to you and ask some questions about whether or not that's appropriate. And so again, our key concern is making sure that these assets remain where they're required to by law, and that they remain in the nonprofit sphere in a way that's beneficial to the public and serves the interests that the dissolving corporation was intended to serve. And then the next thing we look at is obviously any concerns we have about the specific disposition of the assets. Does it look like those assets are going to an organization that's related to an officer or director of the dissolving corporation? Is there any concern about self-dealing? Is there any concern about waste if the dissolving corporation doesn't seem to be taking reasonable steps in identifying beneficiaries of its remaining assets to be distributed, or just seems to be, again, maybe providing it to an organization they have some other contact with? We're going to look at those very closely to make sure that there aren't any issues of private benefit, private inurement, or just generally corporate waste or fraud. Obviously, dissolving corporations are generally not in a place where they may have a lot of assets, but we are concerned that to the extent there are assets, that they not be subject to any ongoing waste or fraud. And so that's basically what OAG is going to be looking at when it gets a notice of dissolution. And we will be reaching out to organizations to talk with them. That process will continue on, as I'm going to discuss in a minute in our frequently asked questions section. But it can definitely take a while, and we will reach out to an organization to get as much information as we can, particularly on the distribution of assets. Some organizations move forward with the articles of dissolution and the notice to the Attorney General, and 6 months later, 9 months later, they're still winding up their assets, and we're still talking with them saying, we need a final accounting, we need to know where these assets are going, and so that way we can close out our review of the transaction. So moving on to the slide called Articles of Dissolution. This is just basically the formal regulatory process that a dissolving corporation needs to follow after giving notice to the OAG, and that's basically to file those articles with DCRA. DCRA is the regulatory agency in the district that's tasked with registration and licensing of nonprofit corporations. That is not the Office of the Attorney General. That's another question we frequently get. The Office of the Attorney General looks at enforcement of the Nonprofit Act, as well as making sure that charitable trust law and other law relating to nonprofit organizations is appropriately applied, but we do not handle the mechanics of registration and licensing. That is done through DCRA. And so when you need to file your articles of dissolution, those should be filed with DCRA. There's a form that's available on the website. You know, it's quite clear to fill it out. You can, I believe now, electronically submit all of that. And then there's a filing fee of $80. So on the one hand, that's a pretty easy and simple way to provide the necessary regulatory notice and file the articles of dissolution. But as we've all been talking about today, that's definitely not, I think, the most complicated part of dissolution generally. And now I'm going to talk about a few frequently asked questions regarding notice to OAG and regulatory filing requirements. And I'm happy if anyone has any questions they'd like to ask on the general subject of the formal requirements and notice to OAG. I'm happy to discuss those either now or at the end of the presentation. So we get a lot of questions, understandably, about the timing of the notice to OAG versus the timing of the articles of dissolution. And so one of those is, does OAG have a form to be filled out or require a payment? And the answer to that is no. You know, we require the notice with the factors that I discussed earlier and that are stated in the statute, but that notice can come to us, you know, in many forms. Generally, people send us letters and there's no payment involved. The only payment is the payment of $80 that's required when you actually file the articles with DCRA. And then the next question, actually, you know, these questions go together, I think, which is, when does the dissolution take effect? And does the process of notice to OAG delay dissolution? And the short answer to that is no. The dissolution will take effect when DCRA provides the notice of the effective date following the filing of the articles of dissolution. And that is a parallel process to what OAG is doing in terms of its receipt of the notice and its review of the proprietary, the appropriateness of the various parts of the dissolution that we see in that notice. And so the short answer is OAG's review won't delay the dissolution. However, if we are concerned about particular parts of the dissolution or believe that there's some kind of problem in terms of the disposition of assets or some other factor that would violate the NCA, we can still take an enforcement action even if the corporation is dissolved. So the fact that DCRA might have formally filed the articles does not actually insulate a corporation from further review by OAG. And again, if we have problems that can't be resolved with the dissolving corporation, you know, we would investigate and could take enforcement action to stop a wasteful use of nonprofit assets, or if we were again concerned that there were violations such as private benefit or some other very clear violation of the Nonprofit Corporation Act. So our jurisdiction over those aspects of the Act certainly continues after formal dissolution of the nonprofit. So I think if there are any questions, I'm happy to answer them right now. And
Catherine,
if not,
I've got two questions. The first question is, if an organization is considering a merger, do they need to follow similar steps to the dissolution process?
The merger process is separate from the dissolution process, so it would be slightly different. There are specific situations that relate to nonprofits. For instance, if you're a healthcare nonprofit and you intend to merge or to provide a substantial amount of your assets to a for-profit company, there's a separate provision in the code that requires notice and approval by the Attorney General of that transaction. But a typical merger is not considered to be the same thing as a dissolution.
Okay. And then the second question I had was, let's see. Oh, actually, this is probably more, I think maybe more appropriate for Lauren. It's whether or not in the, for smaller organizations who wouldn't typically be filing for an audit, they wouldn't still be expected to file a final audit, at a time where they would also be filing their 990. Is that correct?
Yeah, I think that's probably.
Sorry.
I think that's probably a question for Lauren, so she should go ahead.
Yeah, if I understand the question correctly, if the organization does not typically do formal audits in connection with its tax filings because it's a smaller organization, then that's correct. You wouldn't have to do a final audit just to dissolve. And Catherine, maybe it's my understanding, but Catherine should confirm that when you send this notice to the AG that says the amount of your remaining assets and the amount and your intended distribution of those assets, those aren't required to be formally audited numbers. So short answer is if your organization is smaller and doesn't typically do audits in connections with its tax filings, there's nothing in the code that requires you to do an audit in connection with dissolution or your final 990 filing.
And that's correct. If you don't, as a matter of course, need to or prepare audits, we wouldn't request that you do one just in connection with dissolution. We would want to obviously be able to see financial statements and see an accounting of the assets, outstanding liabilities and proposed distribution of any remaining funds, but that wouldn't necessarily need to be through a formal audit.
Catherine, this is David. I have one closeout question for your section, if you don't mind.
Sure.
Which is, did I hear you right? And can you confirm, does DCRA actually exercise any discretion after the filing of the articles of dissolution, or is it pretty much just accept them and file them and then send out a notice to that effect?
It's pretty much accept them and file them.
Yeah. Okay. So there's no hurdle that we have to think about getting over. We just file them, and then I suppose we could just have them illegible or something, and they wouldn't file that, but they don't exercise any discretion otherwise. Okay. Thank you.
So I think that's the end of my discussion, and I'm going to move it over to Lauren to discuss more about winding down.
Great, thank you so much, Catherine. And the question David just asked is a really great segue into my section, because when an organization files its articles of dissolution with DCRA and those are accepted by DCRA, it becomes a dissolved corporation. But that doesn't mean that it has to completely cease the wind down process. A dissolved corporation still has the authority it needs to continue winding down to dispose of its assets and settle its liabilities. And so that leads nicely into my segment, at least the first part, which is disposing of claims. And these provisions of the code, there's this slide and the next slide is going to talk about how to dispose of claims that are known to organization and how to dispose of claims that are contingent or unknown. And in the first instance, I would say, at least with respect to this disposing of known claims, we do not often see these provisions of the code used. The last bullet here says these actions are optional. They're not required to be followed by an organization. And just because of what we've been talking about, the process for filing, we don't see this often used for known claims. And I'll explain a little bit more why, but first let me explain what the code says, which is following dissolution, once an organization has filed its articles with the DCRA, it can dispose of known claims, which are unpaid obligations to creditors, by giving creditors a notice that says, we as an organization have dissolved, we know you have a claim for X amount, and you must submit notice of your claim to us at this address within 120 days in order for your claim not to be barred. And anyone who doesn't respond to that notice within the 120-day period, their claim would be barred and they could no longer enforce it against the dissolved corporation. Practically, we don't see these used very much because if you know of a claim, if you know of a creditor, you would have to pay it to the best of your ability before filing your notice to the AG that says we've settled all of our liabilities. And you have to send that notice before you file your articles of dissolution. So we don't often see these used, and in the frequently asked questions, I'll go into some better strategies for settling claims if you don't have sufficient assets to do so. But this is one way your organization could use these provisions to try to at least get a set boundary on what claims exist by publishing this notice, and then anyone who doesn't respond within the 120 days would be barred. The next slide is, which I'm trying to get to. Yes, so the unknown claims and contingent claims is a little more interesting and might provide a little more benefit than the known claims provisions. And unknown, we have here that it's unknown and contingent claims. This would include anything like an ongoing liability, or if you had a wrongful termination suit, those things would fall into this category. And the way a dissolved corporation could dispose of these claims is by publishing a notice in a DC newspaper that says, this is the name of our organization, we've dissolved, and you have 3 years to submit a claim from the date of this publication. And then any claim that is not submitted within the 3-year period would be barred. The one real benefit that an organization gets from publishing this notice is if it then wants to go to the Superior Court of DC and file an application, it can say, my organization published this notice to say we've dissolved. We don't know what kind of claims are out there or who might bring litigation against us, but here's what we do know. And the DC court can say, okay, here is the amount you would have to set aside in escrow to satisfy all of those claims. And then if the organization sets aside the amount determined by the Superior Court, that would be the extent of its liability to those claims. So even if a claim popped up 2 years after dissolution, it would be limited to the amount set aside in escrow by the dissolved corporation. Again, these are optional actions. They are helpful in that they provide a bit of finality to the dissolution and a little bit of comfort, but we don't often see them used, given that many nonprofit organizations attempt to settle all of their known claims and unknown claims before providing the AG the notice that says we've settled all of our liabilities and we're ready to dissolve. And finally, I'm going to get into the potential liability of directors and officers, which is where we get a lot of questions, and it's probably the meatiest topic in dissolution. And we're going to start by talking a little bit about what is required of a director and officer. And so we've talked earlier, I think Brian, when he talked about wind down, discussed that each director and officer has a duty to make reasonable provision for the payments of claims. That's a duty that arises in connection with dissolution. Above and beyond that, the directors and officers' fiduciary duties still exist. So the duty to act in good faith and in the best interest of the corporation with reasonable care, those duties that exist throughout the life of the corporation continue to exist in the context of dissolution and after a corporation has submitted its articles of dissolution. And a few ways that we recommend avoiding breaching these duties are things like private benefit, corporate waste, fraud, and self-dealing. We'll get into some examples of those in the frequently asked questions, but I think Catherine also spoke a little bit about that and when she talked about the OAG's enforcement rights. And the procedures I talked about on the last two slides about disposing of known claims and unknown claims, pursuant to the code, those do automatically satisfy directors' duties for the reasonable provision for payment of claims. But as I noted, we don't often see those provisions of the code used. And finally, creditors may try to sue directors and officers directly for breach of this duty, where the creditors believe there would have been more funds if a director or officer had not breached. And so a way that could arise is if a director, for example, sold an asset for below fair market value to his cousin, and then a creditor comes by and there's not enough money to pay the creditor, and they say, well, you had an obligation to not engage in self-dealing. You engaged in self-dealing by selling an asset at below market value, and now there's not enough money to pay my bill. So moving on, there are limitations though in the code, in the DC Nonprofit Act, for the extent of liability for directors and officers. And this differs based on whether a director or officer is compensated or unpaid. So unpaid directors and officers who perform services for a corporation cannot be held personally liable for the corporation's debts. There is an exception to that if the corporation has total annual expenses of above $100,000. In order to benefit from this limitation on liability, the corporation would need to maintain a certain amount of liability insurance, which is included on our slide. And then compensated officers and other employees can be held personally liable for acts or omissions of the corporation, but the total amount of the liability cannot exceed 12 months of compensation for that officer or employee. So these limitations are subject to a few additional exceptions, which I will get into on this slide. So those limitations would not apply to claims involving willful misconduct, improper personal benefits, or intentional violations of criminal law or actions taken not in good faith. We've provided some examples here. These actually came from Catherine at OAG, and I think some of them are really helpful. So if an officer or director committed fraud involving the use or receipt of nonprofit funds, they would not benefit from those limitations of liability we just discussed. The same thing goes for engaging in self-dealing or for use of nonprofit funds that were not appropriately ratified by the Act or not authorized by the board, or use of any funds for a purpose that's not related to a charitable mission. So if it was used for a for-profit purpose. In all of those cases, the limitations on liability we discussed for the officers and directors would not apply. In addition, if an officer or director goes beyond the scope of their authority in connection with the wind down, the personal liability may also result from that. So if the corporation takes on a new contract or a new debt that is not appropriate in the context of wind down, an officer or director may be held personally liable for that debt, as it's beyond the scope of wind down activities, which should be limited to, gathering your assets and paying off your debts. And finally, we just want to highlight that while these are limitations on liability, they don't provide a complete defense to a legal claim. And I'm going to get into a few frequently asked questions here as well, but similar to what we did in the other slides, I will welcome questions from attendees at the end. So the first one is, how do directors and officers ensure reasonable provision for the payment of claims? We talked a little bit about this. You can choose to use those provisions of the code that talk about disposal of known and unknown claims, and that's one way to ensure reasonable provision. But more often than not, we tend to work with nonprofit organizations in gathering assets, gathering liabilities, seeing if there are enough liquid assets to cover those liabilities. If not, determining whether there are enough assets that could be sold at fair market value to pay for those liabilities. And finally, if there's still not enough to make reasonable provision for, or to fully pay off each claim, as David mentioned earlier, sometimes it's the best course of action to do a somewhat prepackaged bankruptcy and just approach all the creditors and say, you know, this is how much we have. We want to make reasonable provision for all of your claims, and divvy it up just fairly and equitably among the remaining creditors. And so what are some examples of possible breaches of fiduciary duties? I think I talked about this a bit already, but in the context of insolvency, the directors have to make reasonable provision for claims to creditors. Some of the ways we see those duties breached are improper spending of corporate assets, favoring one creditor over another, if failing to achieve the best price in the sale of an asset, or other actions. And typically what we look out for are self-benefiting transactions, self-dealing, any claims that might involve conflicts of interest, where director didn't disclose that they were had a personal or private financial relationship with someone to whom an asset was sold. So the best way to avoid breaches of fiduciary duties are really just to avoid those things, the conflicts, the self-dealing. As Catherine Jackson mentioned in her presentation, those are the things that the OAG is going to look out for. And as long as an officer and director has not committed those things, we often see that they will have acted in the best interest of the corporation. And finally, what happens if a claim arises after dissolution? The answer to this depends on whether the corporation published the notice in the newspaper that we discussed a few slides back. If they have published that notice and they went to the Superior Court and asked for how much money they should put in escrow to satisfy claims, any claim that arises after dissolution would be subject to that court order and limited to the amount set aside by the dissolved corporation. If the claim arises more than 3 years after dissolution, it would be barred so long as the corporation published that notice. If the corporation didn't publish that notice, the code doesn't specify what would happen if the money is gone and the directors and officers have acted in the best interest of the corporation and did everything, upheld their fiduciary duties. We typically advise clients that there probably wouldn't be much relief for a claim that came out, 1-2 years after dissolution that nobody knew about. But what we would look out for there is just if an officer or director breached a fiduciary duty, that's where we start to see some concern about later arising claims. But I am done, but I don't know, Daryl, if you've received any questions on these points.
I do have a question I think is appropriate for this section.
Okay.
If a corporation has employment contracts, for example, and they've realized if they move forward with dissolution, but there might be insufficient funds to fulfill the entirety of the employment contracts, what's the best course for the folks leading the organization?
I'm not an employment lawyer, so that's a difficult one. I can talk about, and I think David Martin, we ran into this once. There are provisions of the WARN Act that require certain notice and compensation to employees when you're laying off employees in the context of a dissolution. But I cannot advise on those right now, as I'm not, I'm not versed in them as I'm not an employment lawyer, but in the context of what we've talked about, if it's an employment contract that guarantees a certain amount of compensation, I would think that would be viewed as any other liability or debt of the corporation and should be treated in the same way as any other debt, obviously subject to those employment law issues that I cannot advise on, but we could follow up if need be.
No, I think that's right, Lauren, and the WARN Act for layoffs only applies, I think I'm right on this, to organizations that have more than 100 employees. So you can, if you have a big nonprofit, you need to be thinking about layoffs. And then the contract itself would, I think, just inform the negotiations, and it will be a negotiation. Sometimes an officer that has been with the organization for some time and has an employment contract, has a lot of skin in the game emotionally and substantively, and is not, understands that the organization may not be able to pay fully and will negotiate a settlement, or so I think it's going to be very much case by case, but it's a definite issue.
No, I appreciate that answer. I think that's really helpful advice, and that's typically where we've been able to share some advice in the past that and thankfully for the most part, we don't see a lot of nonprofits with employment specific contracts, but they do come up from time to time. So that's really helpful to share.
Yeah, it's no question. And sometimes you have a sort of a messy situation where the officer is, there can be some blame associated with dissolution sometimes, and it can be sort of ugly, but I hope most of us don't have that happen most of the time and therefore aren't that expert on it.
And I don't see any more questions, at least popping up in our question box right now, but if anybody wanted to share some final thoughts before we close, this would be a good place to do so.
I'll just jump in on that note quickly. Earlier on, Susie discussed that holistic decision making about a dissolution, and I find this is one of the nuanced areas in the dissolution process, because there's a fine line between telling too many people too much too soon and not telling enough people enough when they expect to hear it. So you have employees that I think have a big stake in a dissolution, fundraisers and funders have a big stake, and of course the board does. And it's oftentimes complicated, and I don't think there's any hornbook or set answer on how you have these discussions, how the board does sort of consult with enough people and make the right decision by those people. So if you're dealing with this and you think it's simple, or you think it's complicated, I can tell you you're right. And if you think it's simple, it probably won't be. But nonetheless, a board has to really make a good decision, and we've usually found that if they don't check with donors, big donors that is, and if they don't understand their employee sentiment and who's going to stay around with them to do the dissolution, it doesn't work very well. So communicating during the pre-decision making and as part of the decision making is a very complicated, nuanced, and judgmental area.
I think that's really helpful advice to share, because in the cases, particularly with organizations losing funding and trying to make these determinations, we have a tendency to recede and to not share enough information so that it becomes a surprise, or whether it be to the other folks in the community in which we serve, and certainly to employees, and to donors, and to folks who are invested in the organization.
Yeah. I liken it, frankly, it's a transaction in a way. It's a transaction, and I liken it unto an M&A transaction where you have to know enough about what you want to sell for or what you want to buy for, but you don't want to talk about it in such a way that you queer the deal or other competitors are there. So it requires some real hand-holding, I think, by attorneys that are helping corporations and to look out for these factors and to manage these factors.
Yeah, you're exactly right. So I think, as we don't have any more questions, I think we will end the webinar, and let me give a hearty thank you to our panelists, and let me also say, feel free to virtually applaud if you will. I'm going to do that right now. We will thank Covington's David Martin, Lauren Racketon, Brian Yang, Susie Tumanian, as well as OAG's Catherine Jackson. Again, thank you guys so much for being a part of this. The Pro Bono Center will be sending out a survey to all of our participants, so feel free to share your thoughts there as well. Also, I'd like you to remember, if you'd like to share the webinar, it has been recorded, and you'll be able to find slides and audio at www.lawhelp.org/DC/CED. Thanks again to all our presenters, Covington and the Office of the Attorney General of the District of Columbia for partnering with us. Have a wonderful day, everyone.